Good afternoon or good morning for those of you in the West Coast. And thank you for joining us today for the webinar regarding the Supreme Court's tariff decisions and how those questions are playing out regarding refunds and other issues that the courts are continuing to address. I'm David Carter. I am President and CEO of the Ecommerce Innovation Alliance and also a member of the legal team at Postscript. And it's a pleasure to have you all join us today, as well as Ned Steiner, who is joining us to talk about these important issues and this very rapidly developing area that continues to evolve even minute by minute, as we were just talking backstage. So with that, let me just provide a little bit of context for the discussion. The E-commerce Innovation Alliance, on behalf of its 20,000 members, has been paying close attention to these tariff issues in the way that they've been impacting businesses across the country. We've also played an active role in litigation on some of the issues, and in particular with regard to what was referred to as the de minimis exception, which is an issue that we may get to in more detail later in the discussion, but that it continues to be part of active litigation as well that is still in the courts. And so we wanted to bring this briefing to you all to try to give you up-to-date information about how these decisions and the subsequent issues that the courts will be deciding are likely to impact your businesses. And so we're very thankful that Ned has been able to join us and talk about the latest information that we have and hopefully address some of the questions that you and your business may be confronting right now. So with that, Ned, if you want to jump in and provide a little bit of additional context and background about your experience in this space, and then we can get started on the substantive content about the decision and where that takes us. Thank you.
Well, thank you, David, and thanks to everybody at EIA for the invitation to speak. A very timely conversation. So timely, in fact, that the ground is shifting beneath us even today, as David alluded to. And when we first started looking at some slides to sort of go over some of the issues that have been raised, and I was looking at maybe updating them, I realized that as soon as I started updating them, they probably have to be updated again. So we'll talk, the slides will be there as a way of raising various issues, and we'll talk through them and talk about what the focus is on for the moment. But I think all of the issues that the slides raise are pertinent and will become more or less important as we go through with this process. So just again, my name is Ned Steiner. I'm Managing Director for International Trade and Government Relations at Sandler, Travis & Rosenberg. STNR, for those of you who are not familiar, we're a law firm that does trade and customs issues. Myself, I'm not an attorney. I do the consulting and lobbying for STNR. But I have behind me an army of customs and trade attorneys. And if you have any questions about the specifics, please feel free to reach out to me. And if I can't answer your questions, I'm sure that I have colleagues who can. But with that, maybe we can get into the substance.
Excellent. So you want to talk just a little bit, Ned, about for those that maybe haven't paid attention specifically to the litigation, sort of the multiple steps along the way of how we got to where we are today with the Supreme Court decision and now these open questions on refunds as well.
Yeah, it's a little bit of a tortured story. The two main cases were brought related to the constitutionality of IEEPA tariffs. There's the V.O.S. case and the learning resources case. V.O.S. went through CIT in the Court of Appeals of the Federal Circuit, and learning resources went through the district court. But ultimately, they came together, if you will, and went before the Supreme Court. And the Supreme Court made its decision. It was a very straightforward decision with a 6-3 vote. So a strong decision where the decision was written by the Chief Justice Roberts. In this course, now that IEEPA tariffs have been ruled unconstitutional, and that's all IEEPA tariffs. So that means the reciprocal tariffs, that means the special Brazil tariffs, the Russia tariffs on India, which had been removed, but still were out there, and also IEEPA tariffs associated with Iran, potentially. So that doesn't remove, as David was alluding to before, doesn't remove all IEEPA related action. There's still the de minimis, issue, which is pending. But as far as IEEPA tariffs are concerned, they have been ruled unconstitutional.
Okay.
And go ahead. Sorry.
Yeah, I was just going to break that down a little bit because, again, some people may not be super familiar with the different courts that you mentioned early in your comments. But the CIT, as you referred to it, a Court of International Trade, how does that differ just basically from a regular federal court? Like, what's its 30-second origin story so that people can have an understanding of why there were two cases that were kind of progressing up to the Supreme Court?
Well, I mean, the Court of International Trade is the court that makes decisions about customs issues, about trade-related cases, and is the traditional court, if you will, for international trade. It's interesting, maybe I'm getting ahead of myself a little bit, but there's this question now about universal jurisdiction, and don't want to get too far in the weeds, but the generally speaking, the court is seen as having a necessarily universal jurisdiction because it deals with imports which may come in at various ports throughout the country, and you don't want to have different rules for different ports, and so necessarily it has a universal jurisdiction, as opposed to other courts whose jurisdiction I wouldn't say is curtailed, but has been questioned subsequent to the CASA case, which says that just because one federal court rules, it doesn't necessarily mean that it applies to every district in the country. Sorry, go ahead.
Yeah, no, I was just going to say, I think like to help translate that a little bit, it's pretty unique, right? Like we have a federal court system that it's presumed judges can take up almost any type of issue, whether that's any type of federal law issue, whether that's patent, civil rights, criminal. They have this broad array of issues that they work on. And in the US, we don't typically have specialized courts. And so the fact that Congress saw fit in the past to create a court that's really specialized and really kind of focused on international trade, I think just for our audience is kind of reflective of how important they believe these issues are and how important it is to have that uniformity that you spoke about, right? Like instead of having a bunch of different judges come out with a bunch of different decisions, they created a mechanism to try to create this uniformity for the country. And that's kind of where ultimately the Supreme Court decided it was the right forum, it was the right court to be looking at these important issues about the intersection between this power that Congress granted to the president under the International Emergency Economic Powers Act, or IEEPA, as you refer to it, and whether or not that grant of authority gave the president the ability to go and impose these tariffs on countries all across the country. And so I think it's important just to contextualize that decision that the Supreme Court said, yeah, that is an issue that really needed to get addressed, and the proper route for it was through the Court of International Trade, not going through the regular judges sitting in a federal courthouse somewhere else.
Right. That's absolutely right. And for that reason, the learning resources case is going to be dismissed because the district court does not have jurisdiction. The Supreme Court found that the district court does not have jurisdiction. And so everything has to be run through the CIT, and it's the CIT is really the one that's going to call the shots from here on out.
And I
The
think
court,
that's the other critical part of this, right? Which is to say, now that the Supreme Court has made its determination, then this kind of goes back to the Court of International Trade to implement the Supreme Court's decision, and that's the big piece of the unlock here that we're going to get to about how refunds might be managed and where the process goes from here.
yeah, absolutely. And just to, you know, underline that fact, the president himself and some people in the administration have said, it's strange that the Supreme Court didn't say anything about refunds, and it really isn't strange because that was not the question that was before the court, and it was always understood, I think, by people who were following the case, that the Supreme Court would make a decision about the constitutionality of the administration's action, and then CIT would figure out what the implications of that were, and if refunds were to be made available, how they would be made available. So, but anyway, we will talk more about that in a minute. First, this is the summary of the various opinions. I think Roberts did a good job. I mean, I think that it may, he had I think a fairly narrow decision, a narrow opinion. And he didn't get into major questions and generally, and just said, look, you look at IEEPA, it says regulate, it doesn't say tariff. The power of taxation, which tariff is essentially, is in the hands of the Congress. Congress did not delegate that explicitly, and therefore, basically the president has colored outside the lines, did not have the authority to impose tariffs.
Great. And I think here for the audience, probably the thing to understand is there was a lot of writing. It's like 170 pages of text that the justices created in the period of time before this decision came out. And the majority opinion, which ultimately 6 of the justices signed on to, is really kind of what matters from the perspective of what happens at this point in time. The other concurring opinions, the dissenting opinions, they raise interesting issues for lawyers and people to think about in the future. But from a practical perspective, and if you're running an e-commerce business, the decision of the majority, the 6 justices that signed on that, is really what's going to guide the actions of the Court of International Trade as we progress from this point forward. So let's dive into a little bit about that decision and ultimately what the 6 justices decided here.
So, as I was alluding to, it's I think a straightforward, narrow ruling that says IEEPA does not grant tariff power, and I think it's actually a good ruling, in the sense that they did not try to parse. They didn't say, okay, we take issue with the executive orders because of the way that they're using IEEPA. They did not say, okay, maybe fentanyl is a legitimate emergency and you could apply it in this case. They left no ambiguity. They said IEEPA does not allow tariffs, end. And I think that's very helpful, because it really gives us a solid foundation, and it means that the administration is not going to try to go back to IEEPA and maybe tweak IEEPA, tweak those executive orders. It's moving on, with the exception of the minimus.
You mentioned the fentanyl issue, and I think probably a helpful reminder that in relying on IEEPA, part of what President Trump said is like, we need to impose these tariffs, at least on some countries, because of the flood of fentanyl into the country. And he said that's the emergency that is authorizing action. Is that accurate, correct summary?
Yeah, I mean, so he used all of these emergencies, which is significant actually, because for a reason I'll point out in a minute. But he declared all these emergencies as a pretext, if you will, for imposing these tariffs. That means that there was an emergency on fentanyl. There was an emergency related to India purchasing oil from Russia. There was an emergency related to the balance of trade, which gave us the reciprocal tariffs. There was an emergency related to Brazil's treatment of its former president. So he kept on putting out these emergencies, and then to justify the imposition of tariffs. Congressional response was to challenge those emergencies, and in fact, we had a positive vote on the so-called Canada emergency in the Senate first, and then in the House, which was going up to the president. And was with the president. Well, actually, I don't think the House had sent it up yet. But in any case, there had been bipartisan votes on basically a vote in disapproval of the emergencies, which is something that Congress could do because it was a national security law. And so, but it was addressing the emergency quality and deciding whether or not it was, it could be characterized as emergency. Interestingly, Congress had not yet dealt with the fentanyl issue. It had not addressed China. So if it had been left to Congress, their remedy would have been to challenge the emergencies.
Piecemeal, one at a time, essentially.
Exactly. And so I think we're fortunate that the court has stepped in and said, we're not addressing the emergencies, whether it justified or not. We're just saying you can't use IEEPA to impose tariffs.
Yeah, and I think as a result of that, it's kind of important from the court's perspective to say we're not sitting in judgment of whether or not President Trump properly declared this issue or this thing an emergency. We're not second guessing the rationale or that decision. We're just saying we don't even get to that point, because even if he's right that they are emergencies, it's not a pathway to get to this outcome of imposing these tariffs. So, excellent.
Yeah. So basically, this is the direct quote from the Roberts opinion. And it's this whole thing of that tariffs, duties, import taxes, nothing of the like is mentioned in the IEEPA law. And then he says the omission is notable. Now, I remember talking with some folks about, just kind of layperson conversations about, whether IEEPA should be constitutional. And some folks took up Kavanaugh's argument, which was, wait, you're saying that you can embargo a country, and the president spoke about this in one of his speeches, I think immediately following the Supreme Court decision. You can embargo a country, but I can't charge them one measly dollar in tariff. That seems, this is like a less extreme action.
Mm-hmm.
Why wouldn't that be permissible? And it's because it's apples and oranges. One is an embargo against that country, and the other is a levy of duty on the American people, which is not allowed to be done by the administration, by the executive. That's the prerogative of the legislature. So there was a lot of conversation about, the emergency and does it make sense and so forth. But I think the court did a really good job of just saying, look, this is in the power of the legislature. They did not delegate this authority. They have with Section 301. The president may impose tariffs under Section 301. It's explicitly authorized. Section 232, The president may impose tariffs and has done so. IEEPA didn't say that. There was nothing in there that was remotely like that in IEEPA, and that's what the court based itself on.
Yeah, this is a little bit more of the language from the decision, but I think kind of reiterating that point that because the Constitution specifically says like the power to impose taxes on American citizens resides with Congress, then that if it's going to be delegated, I think partly what the court is saying here is that delegation has to be really clear. You can't just infer from words that are not directly on point that maybe this is okay. It's got to be a clear link between Congress deciding that this taxation authority gets delegated to the administration.
Yeah, and it's very interesting that all this transpires in the wake of what was called Chevron deference and now is referred to as Loper-Bright, which said that the administration can't go further than its explicit authorization. And I think this just kind of underlines that, right? Congress, and especially on such a fundamental core congressional prerogative, which is taxes and tariffs. So
I'll just keep moving through some of these quotes, but let's kind of get to then this summarization of like what's changed, what hasn't changed as a result of this.
Yeah, so what changed was that these tariffs authorized by IEEPA, they are null and void and invalid, which means that immediately following that decision, they were recognized as being unconstitutional. Now, it's a little tricky because there are three things. There's recognized as unconstitutional, stopping collection, and providing for refund. Those are three different things, even though they flow from the basic finding of unconstitutionality. So, but what it said was that very plainly that IEEPA, you can't use IEEPA to impose tariffs. And so that limited the executive emergency powers from now until forever. There's no question now as to what the limits of IEEPA are. And I would suggest that it fundamentally changes the administration's trade policy. They have come out and said, everything, we have plan B, it's going to be just like before. And the president even suggested, actually, I have more powers now somehow. But I think it has fundamentally changed it will lead to a fundamental change in the administration's policy. We're starting to get a little bit of a sense of that. They just won't be able to impose tariffs immediately for whatever reason. That's just that they don't have that ability to threaten anymore. So I'm sure we'll get late night truth socials that threaten a bunch of other activity, but it won't be 125% tariff on China. So, and it reinforces the tariff authority must come from the Congress, or clearly delegated, like in the case of 301 and 232.
Can you just talk at a high level? I don't know if we have a slide on this later, but could you talk at a high level? It seems like these other pathways that President Trump has now begun to leverage to reinstitute some version of tariffs has more guardrails, more limitations, essentially, on what he can do, how long he can do it, what he has to demonstrate. And so I think partly what you're saying, if I'm teasing this out a little bit more, is it's going to look, even though they were going to say that it's going to be the same, in reality, that's not likely to be the case because the authority that they can rely upon now has these stricter guardrails around it. Is that fair? And could you talk a little bit more about that?
Absolutely. And so I'll start with a very specific example. So in the US EU trade framework agreement, the U.S. had developed this kind of somewhat complicated calculus where if a good had a base tariff, an MFN tariff of less than 15%, then the IEEPA tariff would make up the difference so that the tariff would be increased to 15%. But if the tariff were more than 15%, then the tariff would not be applied. Okay, that worked in IEEPA. That does not work with Section 122. Section 122 requires non-discriminatory application of the tariff, which means everybody gets the same tariff. Now, there is a provision that says, essentially, I'm generalizing, but if the country does not contribute to the balance of payments deficit, we could talk about balance of payments in a minute, but then the U.S. could conceivably exempt the country entirely from the tariff. But you are not able to change the tariff based on the country, based on the product. Okay. So right there, that changes the whole calculus in all of these agreements. And so EU is looking at paying base tariff MFN plus 10%. 10% today, I don't know, 5 o'clock this afternoon, maybe it's 15%. But right now it's 10%. That's the 122. And it's actually, talk about guardrails or limits, the president can only increase it to 15%. Can't go higher than 15%. And it can only be in place for 150 days, at least in the first instance. So there are immediate guardrails on that. The other guardrail, I think, is also what the justification is. National security emergency is so amorphous. The president used it to talk about furniture, right? He said there's an emergency national security crisis with furniture. And who's going to tell him that there isn't, right? With Section 122, it's based on a balance of payments deficit. Now, that is a very specific term. It's not balance of trade. It actually relates to how the U.S. economy in the 1970s that was based on gold, that had a gold standard, and there was a concern about the gold standard and America's ability to pay its debts, and sort of remain within the currency exchange rate band. The economy is totally different now. And in fact, the IMF, some people from the IMF have come out and said, you know what, the United States does not face a balance of payments deficit emergency right now. That's just not an issue. So we anticipate that there might be a case brought against Section 122. I think that will certainly be the case if the president attempts to extend Section 122 past the 150 days. But we might even see a challenge to it before that 150 days is up. So you're talking about guardrails. I think the limits on how much, the limits, the strictures of application, the justification, the potential challenge. There's a lot there. And I think a lot of countries are sort of playing a wait and see game, and you can see that in their responses right now. Well, we're going to continue to make those financial investments, over a period of years, because I think that they can do that without being compromised. But we will see how the administration responds. Do they issue new tariffs on top of the Section 122 tariffs? Do the 122 tariffs stay in place? All of these things are big question marks. But it does speak to this issue that it's not just a carte blanche the way that IEEPA was.
Yeah. So definitely a lot of both countries and then companies in the U.S. will be continuing to kind of watch how this evolves, and perhaps some new and different arguments about the limitations on the president's authority that will potentially spawn more litigation, take more time to ultimately get there. But it is kind of, I think, fair to say we're in a new order in which unlimited discretion that President Trump claimed up to this point doesn't feel like that anyone's going to buy that anymore. That people are going to be more interested in scrutinizing the justifications, the rationale, the time limits, the limits on the amounts, and pushing back in ways that they may have been more hesitant to do in the past. So let's talk about the immediate response. The decision comes out. Obviously, the administration knew that oral argument at the Supreme Court did not go well. Probably not entirely or at all surprised about losing. Maybe they didn't know exactly how they would lose, but it sort of seemed coming out of oral argument that they were going to have a hard time in sustaining these tariffs. So how has the administration responded? And I'm sure this slide is one that you're referring to as being out of date before it was even written. So you can fill in the gaps as much as possible.
Well, yeah. So it was funny because the administration was kind of had two approaches, simultaneous approaches. One was the world is going to end, and the other one is keep calm, tariff on. We have a plan B. You won't even notice the change if by some strange reason we lose this case. So it was a little bit hard to figure out exactly where they were. I think the president was very disappointed because he really was enamored of this provision. I imagine that his advisors had warned him of this possibility, and now they're sort of coming out and having these alternatives. 122 was certainly waiting in the wings. I mean, they implemented 122 the same day that they terminated IEEPA, very much, at least optically, trying to show that there was total continuity and no interruption. So I think as far as other trade tools, Section 122, it's in effect for until July. It's interesting again that it's 10%. The president threatened 15, but we to date have not seen anything official on that 15%. My understanding is that it may have something to do with the fact that the UK was given a 10% rate, and the UK did not want to pay more than 10%. And because of the strictures of Section 122, the US could not give UK a lower rate. And so what the president decided was, okay, we'll give everybody 10, and then maybe we'll follow on with all these additional actions. So what are those additional actions? Well, something else that hasn't been used that could be used is something called Section 338, which has to do with discrimination against US products in a given country. Now, interestingly, it has to be discrimination against the US only. So, for example, if, the UK and Australia and EU are not allowed to sell something somewhere, that's not discrimination just against the United States. So that would not conceivably rise to the level. But 338 allows for, I think it's up to 50% tariffs, and it doesn't have the requirement for an investigation. It's fast acting. We might see something along those lines, but 338 is not universal. I think the reason why the administration went with 122 first is that they wanted that universal baseline that they tried to get with IEEPA. And now maybe they backfill with 338 against certain countries. So 338 is a question mark, never been used before to impose tariffs. That could trigger a whole response as well in a question of constitutionality, et cetera. Things that have been used, 301. 301 is now like the elder brother. Even though before 2018 we hadn't seen that much of it. We'd seen some of it, like for example the US EU beef case was a 301 case, and But that's essentially unfair trade practices. That's where we get the China tariffs. China tariffs were this initial against unfair trade practices, technology transfer, forced technology transfer, IP theft, and then that kind of escalated based on retaliation. But it started off as a Section 301 unfair trade practice. That could be, there are investigations that have been completed where action is pending. That includes a 301 on Brazil, an additional 301 on China, potential 301s. 301 can either be on a single country, on a narrow issue, on a broad set of issues, or it can be on multiple countries. There's a Section 301 on digital services taxes, which includes Austria and France and a bunch of other countries who are alleged to discriminate against U.S. companies by using digital services taxes. So there are a number of 301 investigations that have been completed. Action could be engaged, or there could be new 301 investigations. Similarly, Section 232, national security, we've seen that wielded in a number of sectors. Steel, aluminum, most prominently, copper now as well. We see lumber, timber, potentially pharmaceuticals, potentially PPE. Generally speaking, Section 232 is on a sector, and it is across the board, all countries, unless specifically excluded. And usually it's excluded through negotiations. So we could see more Section 232. Again, you can see, though, that even though 232 is broad, 301 can be broad, none of these are as broad as IEEPA. So it's filling gaps, but with a different tool. And it also requires an investigation. It requires a comment period, review, and so forth. So the benefit for the administration is that they've used these. These are, in fact, tried and true. No one has yet challenged 301 or 232 in the courts, to my knowledge. Gotcha. So I would say that's what we're looking at in terms of tools that could be used is 301, 232, perhaps 338, and we'll see what happens with 122.
Okay. So where does that leave us for any?
Well, this is the thing I unfortunately have to keep telling people is that I've noticed, particularly throughout this year, is people are always trying to get to a new stable state, right? They're sort of thinking, okay, there's something new. We go back and forth on it. We debate it. We argue about it. But then ultimately that argument is resolved and we have a new stable state that we live with. And then that's in place for the foreseeable future until the next issue comes at some later date. The hallmark of this administration is that the churn never ends. There are, I would say, peaks and troughs for sure. I would say now we're in a trough. In the sense that we just had this decision on IEEPA and we just got Section 122. And so everybody can look at it and say, oh, MFN plus 10%. I'm good. But we don't know how long that'll last. We don't, 122, is that just until July or is it longer? Or does it get challenged in court? Are there these new tariffs, 301, 232, 338? So, it says businesses may face a transitional period of policy uncertainty. I mean, how do you define transitional? It's a challenging environment because it makes it, and I work with apparel companies who say, like, I'm trying to plan for, spring 2028. Like there's no, and how am I supposed to set my pricing? And how am I supposed to, they're very frustrated, and it's a challenging environment. Go ahead. Sorry.
Well, no, I was just gonna say, like, it's not just pricing, right? For a lot of companies, they're looking at the supply chain and who is manufacturing their goods. Obviously, a lot of manufacturing before this Trump administration term started, a little over a year ago, a lot of manufacturing happening in China, people reevaluating whether or not that makes the most sense. Should they shift to manufacturing facilities or try to identify or create manufacturing facilities in other countries, potentially back in the US, but still lots of headwinds against doing that. And then you have this decision, which is something that people have been waiting for a long time. Any thoughts about that specific issue around manufacturing in China, and what's the landscape look like with regard to China for companies that are either have embarked on or were preparing to embark on changes in their manufacturing?
Yeah, it's tricky because I think in Trump one there was very much a push of get out of China, and that could be, go to Vietnam or Cambodia or Indonesia, and it would be great if you came to the U.S. Now it's very much come to the U.S. Like we want you to come to the U.S. Although the incentive to come to the U.S. is, if you don't, we're going to make life difficult for you. And as I've said, like we don't have like a carrot and stick policy. We have a less stick and more stick policy. So I think there. I mean, to be fair to the administration, there are a lot of people who got out of China. Now, whether they did that because of what the administration did, or partly, or in whole, or I think it's really on a case by case basis. I think a lot of folks said, you know what, maybe we have all of our eggs in one basket. Maybe that's not the smartest thing. China's been difficult, and so let's take advantage of this opportunity, find some other sources if we can. And so there has been people pulling. Has been people pulling out of China. There's been some onshoring. I don't know. It'd be difficult to quantify that. But there certainly has been movement out of China, either Vietnam or in some cases to Mexico. And so I think China's a very interesting case given this administration because, part of the strategy was obviously to isolate China. You had the 301, the MFN tariff, the 301 tariffs, you had the fentanyl and the IEEPA, but right now, paradoxically, like China has about the same tariff rate as everybody. I mean, they have the 10%, and they've got the 301. The 301 is an addition, but they're probably as competitive as ever. And we've got the president saying, and I'm going to meet with Xi 2, 3, 4 times this year. So there's been sort of deals and follow up on phase one and so forth. So the administration seems to have a very schizophrenic attitude towards China. It's both the biggest threat and biggest competitive, and I don't know what the terminology is for right now, strategic competitor or whether it's a threat. It's seen as the number one economic threat for the United States. But at the same time, the president is engaging with China. And I think he sees China as a big potential source for investment, for purchasing of U.S. goods. But having said that, I think China remains a big question mark because Congress is very wary of China.
Mhm.
And I think that's fairly bipartisan. Republicans might be a little bit more hawkish than Democrats, but in some ways, I think Congress is more hawkish on China than the president is. So, it remains a big question mark, which I think is significant because that's going to continue through this administration and into the next.
Ned, looking at time, I want to move to a couple other subject matters, but I'm going to summarize that. It sounds like if you had one of those magic 8 balls and you like turn it over, 50% of the time it would tell you to keep going in China because chances are the administration will come to some resolutions, tariff rates will normalize, and it won't be the cost going forward that it may have looked like. The other 50% of the time, it'll say, well, they've got enough tools in their tool belt that they'll continue imposing more tariffs on China than other countries. So making a shift makes sense for your business. Like that's what I'm hearing. Is it really is, as you said, schizophrenic. It's not a clear like trajectory on ultimately what's going to happen with China. Is that a fair characterization?
Yeah, it is. And I think that's the reason why you need to look at your fundamentals as opposed to try to game where the US is going to be, because it's very difficult to predict. And I think the overlay is the affordability question. Regardless of how people feel about China, the last thing that the US wants to do is add additional cost to consumer products in particular. And so they're going to be very wary and hesitant, I think, about adding on to China tariffs from here forward.
So let's, in the time period that we have available to us, let's use this as a game plan. Let's spend just like a moment on de minimis because it's still in the can. Let's spend a couple minutes on refunds because
Sure.
that's obviously a critical part of the conversation for people. And then we'll check in and see if there's any questions from the audience. But let's spend a minute or two on de minimis and then a couple minutes on refunds.
Sounds good. So de minimis, I think I said this. I've been talking a lot about this. De minimis is not a tariff power, right? And in IEEPA, it says that the U.S. may suspend privileges, and de minimis is considered a privilege. De minimis treatment is considered a privilege. And so just on its face, it seems like the administration is in a lot better position on de minimis, on using IEEPA to suspend de minimis than it was on levying tariffs. Not to mention the fact that Congress has a backstop of July 2027, where by law de minimis is eliminated. So there are some questions, I think, about given the fact that TIFTIA made de minimis statutory. So I think there's some questions out there. David, you were suggesting that that the plaintiff, though, might kind of run out of gas, conceivably, especially if they sort of see the writing on the wall and say, I don't know if we really, are going to be able. What's our case going to be? And if they don't think that they have a high likelihood of success, they might just decide not to go forward.
Yeah, I think that's always the case. So just for clarification for the audience, the de minimis exception, which allowed goods to be essentially imported without tax or without the tariffs if they were under $800, there's a separate case that was stayed. It was filed at the Court of International Trade by a company called Axel of Dearborn. And that case has been stayed pending the Supreme Court's decision that we've been talking about in V.O.S. selections. And now, just earlier today, this morning, the plaintiff in the case has asked the Court of International Trade to reopen the case to allow the case to proceed to resolution. There has already been briefing and argument on issues in the case that before it got stayed. And so they're looking for the Court of International Trade to decide this issue in the near term. I think what has changed significantly from at least the landscape besides the Supreme Court's decision, the other thing that's been changing in the background is sort of the view of how much when a court issues an injunction, whether that injunction should apply broadly to the administration or should apply narrowly to the parties in front of the court. And there has been a shift in this, while everything else has been happening, that has been shifting in the courts. And so the relief that this case seeks now is very clearly targeted to eliminating de minimis for the one plaintiff in the case. And so it has taken on a slightly different connotation for its impact and the impact that it would have. It would still be important precedent for other companies if the court agrees that de minimis, eliminating de minimis was also unlawful, but it won't have an immediate impact on other companies. And so as a result of that, a number of factors could disrupt potentially the litigation before that issue reached the Supreme Court or they made a final decision on de minimis. And so that continues to be one that will evolve separately and independently from the question about refunds.
Yeah. And just a final note on that. I mean, I think the government would fight like hell against this. And I think it would get sent to the Supreme Court ultimately. And the fact that the Supreme Court ruled against the president the last time around, they might be eager to rule in his favor this time. So I can imagine the plaintiff kind of playing out that scenario as well. But just to reiterate, de minimis, it's been a vertiginous fall from grace since the U.S. was pushing other countries to increase their de minimis during the TPP, the Trans-Pacific Partnership rounds. And I think a lot of it has had to do with not just tariffs, but also the requiring the 10-digit HTS number, which creates the flags for the participating government agencies. All of those agencies want more visibility. And so I think de minimis is a harder and harder political sell. It's not entire. There's still people talking about it. There's proposed legislation in the House. So there's still discussion, and in fact, Customs has indicated that they are looking for some sort of low value shipment solution, which is not formal entry and not informal entry, because they want to move postal into entry. They haven't figured that out yet, but that might ultimately be the solution as opposed to reviving of de minimis.
So,
okay, refunds.
Everything
hear about refunds. Look, and I would just say, shameless plug, we're helping people with refunds. If you want to talk about refunds, I'm sure my information is in there somewhere. And we can tell you, the long and the short of it is you don't have to file with the court. I know a lot of people have been filing with the court. We just saw FedEx file with the court. It's not necessary to file with the court, but we have seen an increase in companies filing with the court, anticipating that there may be a judicial resolution of the refund issue. Now, very briefly, because this is getting kind of complicated, but there is an A solution and an I solution. The A solution is administrative through customs. The I solution is judicial through the court. Now, the question is, and this is why CIT is so important, and we talked about it earlier, is CIT is going to decide which way they want to go. If they say that something is protestable, that's A, right? And then customs, which has been suspending protests on IEEPA refunds, will then be obliged to start the process for refunds following CIT guidance. CIT might say, do this as quickly and as easily as possible. How many people out there think that that's what they're going to say? They could just say, reverse what you did, electronically, return the funds. Or they could say, okay, customs, we want you to set up a process whereby you review these protests, you review the post-summary corrections, which are the essentially they're protests for entries that haven't been liquidated yet. And then it will be in the hands of customs to resolve. Now, alternatively, the court said, no, we want to review these cases. You need to file with the court. And that's why everybody's filing right now to kind of, it's like reserving a place in line where the line doesn't exist yet, but may exist. And in that case, it goes to this universal jurisdiction issue. It is conceivable, it is possible that the court said whoever has filed with us is now eligible for refunds. And then it gets 300,000 cases filed before the court. I can't imagine that that's the way the court wants to go. Maybe they'll do what's called a test case, where they'll take, a particular case and they'll review it. Once they make a decision, then they'll apply that to every other case, every other similar case. The thing is that there are some wrinkles in how people have paid the tariff. It's not entirely straightforward because there were so many different tariffs and there were partial tariffs. And and then also there's standing, right? Like in V.O.S, some of the people in the consolidated group were not importers of record. They were consignees. So do they actually have standing to file a case? There are a lot of kind of legal issues that have to be worked through. We, Sandler Travis, are taking the position of a very streamlined approach, which I think is particularly appropriate now with the Supreme Court having made its decision. We don't have to say anything about whether IEEPA makes sense or doesn't make sense, or we can just say Supreme Court found this way. We paid IEEPA tariffs. We want IEEPA tariffs back. And we do it for importers of record who have all their paperwork in place. And, we may be in a situation where if the test case gets complicated, we say, notwithstanding that case, we want you to adjudicate our case because we have a different profile. We have a different fact pattern. So right now we have about 30 days within which the court is going to remand the case back to the lower courts, to the appeals court and to the CIT. And then we will find out what's next and we can have another webinar.
So to summarize that, though, you have companies that you are actively working on filings to kind of preserve places. Some are taking a wait and see approach. But in all instances, it seems unlikely that there is a scenario in which suddenly the administration is just going to start cutting checks and they're going to end up in someone's mailbox. Like companies who have paid these tariffs, who believe that they should be seeking a refund, they're most likely going to need to take some affirmative action, whether that's through the courts or through through customs enforcement, in order to specifically request the money back. That's your guess at this point.
Yes, absolutely. You are going to have to take some kind of action. And so what we're saying right now is make sure that you get in those protests for those entries that liquidate. So it's 180 days after liquidation, you have to get your protest in. So check with your broker, make sure that you've protested all of your liquidated entries. For unliquidated, they're not allowing PSCs right now, post-summary corrections. So, you can ask for them, they'll just be rejected. But definitely on the protest side, that's something that you can do, is protest those liquidated entries. There is, just as a parenthetical, there are some companies out there that are paying people for their claims right? I think they're offering almost 80 cents on the dollar right now. That might be interesting to you if, you don't know how this is going to turn out, and you need the cash. The one thing I would caution is you probably will still be required to pursue these actions because you are the importer of record. And so you're the only one who's going to be, able to either ask customs or provide more information to customs or provide information to the courts. And so this is not a situation where you'll get the money and then never hear from them again.
And not have the headache of dealing with it.
You'll get the money, but you also get the headache. So then you might want to think, maybe that's not the best deal, or maybe that's not the deal that I thought I was getting. But there's still, a lot of moving pieces out there, and happy to talk through. And as I said, we are, ready, willing, and able to help people take that place in line with CIT if they're interested.
Thank you. Ned, thanks so much for spending your time with us this morning. I know it's a busy time for you and your colleagues, and so it means a tremendous amount for you to take time to provide this briefing to our members and to give people insight on what is happening, what's potentially coming down the pipeline, so that they can make sure they're in line, get the right place to get their refunds, and then also continuing to watch the evolving situation and how it's impacting their businesses. So again, much appreciation. Thank you to all who attended today. If you do have follow-up questions, I've displayed here Ned's phone and his email address. I'm sure he'd love to hear from you and to help you resolve any of these important issues as they continue to percolate. So with that, thank you so much, and have a great rest of the day, everyone. Bye-bye.